Case number 2259974, count one. Only count one. Police officer resisting and obstructing. This is a habitual offender report offense notice. And also case number 2258771 versus Carlos Durham. Durham is charged on this case with count one, weapons, firearms, possession by felon. Count two, weapons, felony firearms. Count three, weapons, ammunition, possession by felon. Count four, weapons, felony firearms. Count five, carrying concealed. Count six, police officer assaulting, resisting, and obstructing. And this is a habitual offender report.
Ever since I began covering Carlos Durham, I decided to look deeper into the details of his case to understand what was really going on. As more information came to light, it became clear that the situation was far more serious than it first appeared. Official records indicate that he is currently facing a total of 12 separate criminal charges. These charges involve multiple alleged offenses that suggest an ongoing pattern of legal trouble. Notably, two of the charges are connected to possession of a firearm by a convicted felon. Overall, the case presents a concerning picture that continues to unfold as new details emerge.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Delisha Taylor Coleman, P56278, on behalf of Mr. Durham on both matters for bond redetermination.
And Mr. Durham, can you state your full name for the record, please?
At the very least, it appears that the Wayne County Jail has been effective in enforcing its procedures and maintaining order. Over time, the situation seems to have brought a noticeable change in his behavior. He is now identifying himself in a straightforward and ordinary manner. The exaggerated claims and alternative identity he once pushed no longer seem to be part of his narrative. This shift suggests a growing acceptance of reality and responsibility. Overall, it reflects a clear move away from confusion toward a more grounded and rational position.
Yes, Your Honor. As the court has before it, I believe Mr. Durham has a capias with this court, or maybe it was with Judge Elise Bryant. At this point, we'd ask for any capiases to be recalled. That he is a resident of Detroit. He has significant family contacts. I'm looking up his investigation report. I'm looking up the sheet from misdemeanor felony defenders on his behalf. Long story short, we're asking for a personal bond with tether, and
he continues to argue that the court does not have proper authority over him in this matter. This position has been raised repeatedly despite clear rulings to the contrary. According to a previous judge, his history reflects a consistent pattern of avoiding legal obligations. That same judge described him as someone who frequently fails to appear when required. The court also noted unusual behavior that raised concerns during pretrial proceedings. Taken together, these observations contributed to the court's overall assessment of his credibility and conduct.
I'm sorry, what did you ask him? I didn't hear the first part of your question.
Address the the capias of December 14th of 2022.
Yes, go right ahead.
Mr. Durham, were you aware of that court date?
Yes, and kind of no. They bombarded me with a bunch of court dates, and I kind of might have forgot it because there's so many I got to go to.
Okay,
they sent me about 40 different cards with court dates on them.
You essentially made up your court date.
I think so. I got court dates all the way to February. And
he attempted to explain the missed court appearance by saying it was mixed up with many other scheduled dates. The judge was not persuaded by that reasoning and emphasized the seriousness of repeated absences. From the court's perspective, continued detention was viewed as a necessary step. The decision was framed around protecting both the legal process and public safety. Records show that he still has several upcoming court appearances scheduled within the same month. As a result, the case is expected to remain active and closely followed for some time.
Yes, I reappeared. I appeared before. I was on Zoom. I was on a tether. I came to court.
Okay. Your Honor, we believe that this was just a mistake, a one-time mistake. Mr. As the court can see in the register of action, Mr. Durham had appeared at previous court dates, but as he stated, because of the number of court dates, this one fell through the cracks. But he would reappear at all future court dates. These are non-assaultive crimes. We're asking for a personal bond, reinstate the bond with tether. Would the court consider any reduction at all? I don't know if Mr. Durham can post any amount of money. Was there a change in your bond before Judge Bryant, Mr. Durham?
So the what? I didn't hear you.
Was there a change in your bond before Judge Bryant?
Yeah, it was a $10 bond. That's all it is. They said it's a $10 bond. I'm here to get this bond reduced so I can get out of jail.
And you have employment?
I work for myself.
With a heavy dose of sarcasm, he joked about what his legal representation might be called and questioned whether anyone would seriously take it as a professional operation. He spoke as if he were pitching himself as a motivated and ambitious candidate. The comments leaned more toward mockery than a genuine proposal. Beneath the humor, there was an attempt to project confidence and drive. He ended by correcting the pronunciation of his name, insisting it be said properly. Overall, the exchange came across as theatrical rather than substantive.
I am going to wait until we get to the probable cause conference on the 25th with the DSU report to determine whether or not I'm inclined to reduce the charge. I need him to show up at court for something because we're back at the probable cause conference. I want you to listen up very carefully. Your next court date is January 25th. That is a Wednesday at 8:30 a.m. Can you hear me?
Yes, ma'am.
Okay, so you'll be zooming in from the county jail, and you'll have an attorney present to discuss with you any matters reported on the record, okay? So show up for that, well, you have to show up for that. Then your attorney then can possibly discuss something once we have a DSU report, okay? Attorney Taylor Coleman, anything from defense?
That's it. Thank you, Your Honor.
All right.
That concluded the first trial, and attention then shifted to the second proceeding held 2 days later. Observers noted an immediate contrast in tone and presentation. Carlos appeared noticeably different from his previous appearance. His demeanor and style seemed more expressive than before. Each time he returns to court, there is a visible change that draws attention. This second trial continued that pattern, adding another layer to an already unusual series of hearings.
Just sat down about 5 minutes ago. Can you state your name for the record, please?
My name?
Yes, your name.
My name is Carlos Lorenzo, and I'm here to represent the person you got on that paper, which is an all capital name, all capital letters. That's a corporation, and I'm not claiming to be him, but I'm here to represent him. All capital name is all corporation. I'm not a corporation, I'm not dead, I'm not a fictitious entity. So I'm not claiming to be whoever name you have on that paper, which is probably in all capital letters. That's not my name. It's 2 names in this court that sound exactly alike, and only one of them is mine. What name is on that paper y'all have over there? Is it in all capital letters? That's not my name, but it's my property. It's my trade name, and I own it. And I need to know if anybody has permission to use it from me. So do we have that understood? I am not a U.S.
The discussion quickly shifted to a sharp and provocative suggestion raised in the moment. The speaker argued that firm enforcement actions would discourage similar claims in the future. The point was framed as a deterrent rather than a detailed policy proposal. According to that view, clear consequences would reduce repeated challenges to legal status. The remark was delivered with frustration and a sense of urgency. Overall, it reflected exasperation with ongoing arguments rather than a carefully reasoned solution.
On that paper, because that person is a fictitious entity. I am actually flesh and blood.
It quickly became clear to his lawyer that trying to have a private conversation with Carlos would be an exceptionally difficult experience. After just one prior meeting, the attorney realized the challenge of managing any one-on-one interaction. The situation seemed almost comically frustrating, highlighting Carlos's unpredictable nature. Attempting to get through a discussion felt more exhausting than it should have. This early realization likely shaped how the lawyer approached future interactions. In the end, it underscored just how unusual and challenging representing him would be.
I'm not him. I'm claiming not to be
I heard
him.
you. I just wanted to know who you were. Thank you. I had to check there. Attorney Simon, thank you. Listen, you want to speak to your client in private before we go on the record? Because he's still talking.
Sorry, Judge. Can you repeat that, please?
Do you want to speak to your client in private for a moment? Because he hasn't stopped talking for the last 10 minutes. He's still talking. He doesn't know he's on mute, but he's been talking.
I just saw him Monday at the jail, but okay.
Okay. Because I don't think we can have his hearing unless he understands we all can't talk at the same time.
At this stage, it became clear that Carlos needed to exercise much more restraint in court. Using his self-control before speaking could prevent serious consequences. The judge's patience was limited, and any further outburst risked contempt charges. Such a ruling could result in additional jail time, prolonging an already difficult situation. It was a reminder that careful communication in court is essential for anyone involved. Overall, maintaining composure was critical to avoid making the case even more complicated.
Carlos Lorenzo Durham, case 2259974. Mr. Durham is charged with one count of police officer assaulting, resisting, and obstructing. This is a habitual offender fourth offense notice. Also, case 2258771, the People versus Carlos Lorenzo Durham. Mr. Durham is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, stony firearm. Count 3, weapons, ammunition, possession by a felon. Count 4, weapons, stony firearm. Count 5, carrying concealed. Count 6, police officer assaulting, resisting, and obstructing. This is a habitual offender fourth offense notice. Today's the day set for a probable cause conference. Appearances.
Alexander Kirker on behalf of the people, P8628.
Good morning, Your Honor. Jonathan Simon, P35596 for Mr. to both matters.
And Mr. Durham, can you state your name, please?
Objection. I'm not a mister. I just told you that it's two names that sound exactly alike and only one of them is mine. My name has never been spelled in all capital letters, so that is not my name. Whatever name you have on that paper is a corporation and it does not exist. That's not who I am. I'm not.
What is your name,
I'm here to
sir?
represent him.
What is your name?
My name is Carlos.
It was obvious that Carlos's behavior in court was largely performative, aimed more at drawing attention than addressing the proceedings seriously. The judge, much like in the previous hearings, showed no tolerance for theatrics or games. A few additional exchanges occurred between the attorney and the judge, highlighting the ongoing tension in the courtroom. During this session, they scheduled a competency hearing to assess his mental and physical capacity in relation to the case. The purpose was to determine whether he could meaningfully participate in his defense. If you enjoyed following this coverage, be sure to like, comment, and subscribe with notifications on so you don't miss any future updates.